And so that's not the situation here. You give an order that says, basically, with or without your order, I think because of Mr. Branch's word, this won't happen again. But at the same time, it cannot be used to topple government. In a true democracy, you need both. You need people like Carlo Branch, and you need the de facto officer doctrine. But, Your Honor, that's a tight doctrine to apply. If there's bad faith, like in Hoboken, I mean, the only thing the judge didn't say there, quite frankly, is these are a bunch of crooks. That's the only thing he didn't say. But he smelled a scam, and he talked about the bad faith. And more interesting, really, I think, than anything, it resulted in a remedy. They said, throw it out. He was so concerned for the victim in that case that he made sure that he made them whole. And you could do that with money. You can't do that here. Here, the people of Guam have spoken. And so they're going back to the GEC, and they're saying maybe they'll make a different decision. But the legislature has spoken and said that the only thing you're supposed to do on the GEC, people like myself, people like John July, you are Democrats, have always voted when we've lost to certify the results. Is you look at the numbers, and whichever side has more numbers, you certify. Then your obligation is to make those public. And that's really your only duty. And so what we're saying is we're going to go back, but this time they're not asking for different members. They're just saying that they be card-carrying resolution members. And there's no difference. The obligation is mandatory. We can do that right now. And so they're not contesting the results.
But if there's bad faith, then the de facto doctrine won't apply.
To some extent, that's one element, and that's correct. And I think at the very most, when Aggie spoke, and I agree with him totally, I think he was candid with me. He said, we just discovered it. We had to go out and find it. Well, their own case says that's the easiest thing to find, so I'm not shocked that they found it. But of course, the motive in looking for it was strictly to find a way to save them from a decision that the people of Guam made. And that, of course, is a collateral attack. They're really not after the certificate or the certification. They're going after the qualifications of people. Now, another case that has been cited is one, Mr. Chief Justice, where in the proceeding, like Ryder, you said, hey, I don't think Chief Justice Torres is qualified. That's different. Then I get my day in court, and I think the Supreme Court correctly held that. Like, well, no, in that proceeding. So if they jumped forward during that proceeding and said, you're not qualified to sit, they'd be entitled to somebody. But they can't wait for the decision of the people of Guam, the decision of a ministerial body that has no choice, it doesn't have to have anybody there, to make that decision and then say, okay, let's go find another reason how to challenge that decision.
But there were post-election decisions made that were other than strictly ministerial, though, right?
Yes, and they were made in their favor, and that is whether or not to count a recount, and another recount, and another recount, and a hand count, and that was all done. And so now they're saying, but another committee might decide to do something different.
But there wasn't a hand recount.
There wasn't a hand, well, there was a hand recount, Mr. Chief Justice, of 6 precincts. But the statute doesn't entitle them to a hand recount. They just asked for that now. But you know who has the right to do that? The Superior Court of Guam. In Chapter 12, they're entitled. In fact, one time in the Beneventi case, I believe, or the Ada case, I apologize, I may have them confused. I believe it was the Ada case, where they asserted because the statute's mandatory, it says shall. Our Supreme Court said, well, that's when you lay the fundamental elements. It doesn't mean that you just come to court and have a recount. But that remedy, Mr. Chief Justice, is provided for. That what they're saying now is outcome determinative, can happen in the Superior Court of Guam. And that remedy is adequate and it exists. But what they are saying, although as I said, to their credit, they're not challenging the decision of the people of Guam. What they are challenging is the fact that the Supreme Court of the United States has spoken, our Superior Court has spoken, not just in the Lujan case, but in the Klitsky case and the Yang case. We all remember that. I was joking around, my associate Rick, who's a lot younger than me, doesn't remember Yang and how we all waited and waited to see what was going to happen. The firing of Ken North and what happened to all his prosecutions. This is a regular method of operating in a democratic form of government. Just like Mr. Branch's efforts are expected and encouraged and to be congratulated. But at the same time, they can't result in the toppling of government or the frustration. Everything that the de facto officer doctrine is intended to protect. But when you have both of them going together, then you really have democracy. And that's what it's about. Because you have your prospective relief, your remedy, just like in the election board case where judge and now a chief judge Gatewood found the districts all out of whack. Mr. Tanatong was to be congratulated by bringing that. She said, but you don't throw out the board. But it was common language on the island to refer to the board as the illegal board. They weren't the illegal board. It's just the remedy is that will never happen in another election again. That election won't be held. If this, Mr. Chief Justice, was brought ahead of time, just like the districting case, then it would be mandatory. But because it was not brought ahead of time, it's directory. And of course, after these proceedings, it's mandatory. And so this can't happen again.
But they argue that the directory mandatory argument is irrelevant because that only applies when a party seeks to invalidate the election. They're not seeking here to do a brand new election or invalidate the results of the election.
No, they are hoping for new results. They're hoping that the Guam Election Commission will do something that they're not empowered to do by the legislature. They're empowered to tabulate, to certify, and to issue certificates. That's it. And there is a little bit of discretion, and that is, quote unquote, if it's close, and I've appeared in front of them before when I argued on behalf of Senator Pangilinan, and I said, come on, it's a quarter point, it's close. They said, fine. They did a recount, and it didn't make a difference. In this case, they voted in favor of petitioners. They gave them a recount, and another recount, and a hand count, and it didn't make a substantive difference. Did the vote change, the totals change? Sure. But it didn't make a difference. We have to give some credit. Does that mean I have a minute, or does that mean I'm up?
That means you can finish the sentence.
Okay. Halfway through, and I do credit you, Mr. Chief Justice, with your prediction that we could finish this in 4 days. And in 1 week's
did a
time.
very good job of briefing it in a short period of time.
In 1 week's time, we've gone from anticipating inaugurations to the completion of an entire Supreme Court case on technical qualifications of ministerial officers. And if I can leave this court with one thought, it's that the people of Guam have spoken. I only hope that my 10 minutes of participation here hasn't clouded that message. Justice is now in your hands.
Thank you, Mr. Phillips. Mr. Lujan?
Good morning, Your Honor. First of all, the GEC controls the records regarding.
Excuse me, Mr. Martin. Did you lower the close speak?
What you get for these short ones. In any event, the GEC controls the records regarding party resolutions. And
Why do you say that the GEC controls that?
Because I believe that the GEC has an obligation to ensure that its members that are appointed, are appointed pursuant to the, to the statute. And in this particular case, 2101A. And I believe that, in addition, that the GEC has an interest to ensure that everything is proper in order that challenges do not, are not brought.
Mr. Lujan?
Yes.
Doesn't the appointing authority, the governor, have the right to rely on the word of the chair? That when the chair makes the nomination, the parties comply with its requirements?
No, I disagree. I disagree. Simply because 2101A, has this requirement of a nomination being made or recommendation being made by a duly passed resolution. And in 2006, and I believe that we presented the court with that, there was a recommendation by the Democratic Party chairman, Mr. Charles, and the governor's office, the governor's legal counsel said, check, is this his personal recommendation, or is this, the parties, and then attached to that. And, after Mr. Charles was contacted by the secretary, Ms. Charles, Mr. Charles, got the Democratic Party to issue 4 separate resolutions at 2 different times.
But the absence of a resolution to the governor doesn't conclusively establish that a resolution wasn't undertaken.
No.
Or validly passed.
It does not conclusively establish that, Your Honor, but what it does establish is that, in the total absence of that, is that the members that are, that were appointed pursuant to a letter from the chairman, and in the absence of a resolution, that the appointment, the nomination process was flawed the appointment process was flawed.
I don't see how we can jump to that conclusion that simply with the absence of the resolution accompanying the appointment, that there wasn't a resolution that was done.
Well,
I mean, it doesn't, I don't think we can make that leap. It seems like there are additional facts that may have to be uncovered in a lower court action to
Your Honor.
conclusively establish whether a validly passed resolution was done or not.
Your Honor, we did present in the branch declaration. There's an email there in which the secretary to the governor's legal counsel stated that there are only 2 resolutions, in their files. And as the brother respondents of real party and interest argued that those resolutions would go to the governor's office. And so,
But there's no declarations or no evidence from the parties themselves that a resolution was not passed.
well, but in the absence of it, and in the, and the fact that this is being highly contested, and then we have 2 parties here that have not even presented anything to the contrary, then I believe that the court is, can infer that from that absence, that, that no resolution was passed as to all the 6 political members, starting with Mr. Mesa in 2006 when he was, 2007, when he was appointed, with Ms. Ruth, and with Mr. Taitano, and with the 3 Democrats whose appointments were made in 2009. So our position, Your Honor, is that the resolution, the resolution requirement, if I may call it that, the resolution requirement is an integral part of this statute. It's a critical part of the statute. And why I say that is that the old statute here did not require, rather allow a recommendation simply by the party, from which, and then the government picks, from that recommendation. When the law was amended in 2010, or rather 2000, and one of the authors was Senator Copeland, the legislature, provided that rather changed that requirement, and in this case said that that recommendation has to be by a duly passed resolution. The legislature also in another section, and that revision, and I believe in 2101B, the legislature also included that, an additional method for removal of a member. In the old law, it was simply by a vote of 2/3, for misconduct by a member in office. All it required was a resolution from the legislature by 2/3 of its members. In Public Law 25-146, which is now the law that exists here, the legislature also added another provision, a second method for removing, and that is that it be, recommended by a political party via a duly passed resolution. So the legislature, intended, and meant that this provision, be a substantial provision. Then acting Governor Manuel Bordalo vetoed it, and the legislature overrode that veto. And that's how, critical it was to the legislature that this provision be, in place, and that this provision be, be adhered to.
So even assuming that they are not de jure appointees because of the absence of a duly passed resolution, and let's say the evidence is either uncontradicted or on that point, why aren't they de facto members?
Well, because, and I'm glad that you asked that, Your Honor, because simply, let's be blunt. I don't think that rather the respondents here and the real party interest do